Welcome to Hull on Estate and Succession Planning, a series of podcasts hosted by Ian Hull and Suzana popovic-montag. The podcast you are listening to will provide information and insights into estate planning in Canada. From the offices of Hull & Hull in Toronto, here are Ian and Suzana.
Hi, and welcome to Hull on Estate and Succession Planning. You're listening to episode 164 of our podcast on Tuesday, May 12th, 2009.
Hi, Suzana.
Hi there, Ian.
How are you doing today?
I'm well, thank you. How are you?
Just great.
That's good.
That's great. So one of the topics that we are faced with on a fairly regular basis, and we thought we'd talk about today, is the whole question of costs. Now, there's sort of two levels to that question. One is, where do people get paid out of in typical estate contested matter? And secondly, what are the costs, and what does it really cost a client to engage a lawyer? Now, the first one is a little more interesting to talk about from an academic standpoint, and the other one is a little more practical.
That's right.
So we'll see how our time goes, but let's start with the source of costs. If we remember, with situations that turn into a contested estate litigation or estate or trust litigation or contentious administrations, there are various sources of who can pay the costs. Obviously, the first is your client who comes in the room and they meet with you. They're going to pay the costs out of pocket and out of their own personal resources. That's one option. Another option is to consider whether or not the cost in the appropriate circumstance should come out of or be funded from the pool, the whole estate pool, or the whole trust, whatever we're dealing with. And we'll get into a little bit of that, just sort of determine now, like, let's talk about what are some of the factors that would allow a court or a judge to ultimately decide that they think that the cost shouldn't be what would be the normal out of your own pocket approach, that they should be in fact coming from the disputed pool of money.
And I think, Ian, the easiest or the illustration of when you could probably be pretty sure that you'll get your costs out of the trust fund or the estate fund is when you're acting for an estate trustee or a trustee who's looking for advice and direction on how to administer the particular fund that they're in charge of. And as long as they're acting properly and not in a self-interested, motivated fashion, I suspect that it'll be more likely than not that costs would be awarded out of that fund. Of course, we know costs are completely discretionary, so there's no guarantees, but we take a little bit of comfort from the fact that that's typically how we see things unfold.
All right, so when you say completely discretionary, what do you mean by that?
Well, at the end of the day, a judge has can make the decision that the fees will be paid personally by the client, will be paid by the other side perhaps, maybe paid out of a particular fund if it's available. And the fact that there's this discretion means that the judge decides. They look at the conduct, they look at the nature of the litigation, and they say where they think costs should lie. And
because of the wide discretion the judge has, the wide parameters that he or she can work within, the whole question of costs is unpredictable.
Absolutely.
And what about the element of appeal proofing because of the discretion? Let's talk a little bit about that. So once a judge has come to the decision within this wide, broad spectrum of parameters that the law allows you to come to and make a decision, say the judge decides costs come out of the estate for this will challenge that came about, and that the will challenge, well, didn't succeed, but the reason it didn't succeed was probably unappealable. Well, there's no reason to go to the next level. The court wouldn't likely deal with or set it aside. But on the question of costs, how does that get faced when you have the move up to the next level to appeal?
Well, appeal judges will not address the issue of costs, or will they?
No, well, it's a fair question. I mean, that's the whole question when we talk to her. I mean, the courts will be very reluctant to mess with that discretionary decision at the first level. So if you're going to appeal something, the threat of a cost on the appeal in the estate's context is a bit of a veiled threat. It's not likely that it's an appeal court, like you say, will necessarily touch that. They typically will say, you know what, there was a trial judge who was there, they know what's going on, I'm not going to set aside a cost order alone. They might want to set it aside because the trial judge made a mistake in his or her determination, but they typically don't touch costs like you say. But as you also say, or will they? And that's the big threat. And what will the court do? Is there, if you go and you have total victory at trial and then you go up to the next level, and the court sets aside your total victory and hits you with costs. So those are the sorts of parameters that, and really what it comes down to is it's an unpredictable result. So if there's wide discretion, and the source of the funding is either out of the clients personally or possibly out of the pool of money, out of the estate or not. And then we overlay this with the uncertainty, because like with any litigation, it truly is uncertain, A, what a judge is going to do, and B, on the question of costs, because of the wide discretion. So when we are starting a process, and then let's kind of get to the brass tacks a bit here. When we're starting a litigation process in the context of estates, what are some of the things that we know a little bit about how the courts are dealing with it, and quite frankly, it's unpredictable. But what are some of the things that we should start to expect? Like if I'm a client and I'm coming to see you and I'm going to do a classic will challenge. I'm tired of my brother beating me around, not beating me, but beating me to the punch with my parents. He wins the battle, he's the last man standing, and he gets everything under the estate, and I'm coming to you to challenge this. So what are some of the preliminary considerations beyond what we've already discussed?
Well, one of the things that you would look to, I think, in that situation is what that person's entitlement might be under the will. If they have an entitlement under the will, then you've got a pretty good chance of saying, you know, there may be a pool of funds available at the end of the day where you could recoup your costs out of the estate, or you may not. And so that kind of a consideration is something you've got to turn your mind to, because if you are challenging a will and a prior will, for instance, provides for you or doesn't provide for you, that may affect whether or not you've got something to hook onto.
Okay, so let's go through some of the stages then, and some of the cost estimates. And I'm warning, and make my own warning here in the sense that this is our experience, and every case is different. You know, if there's 3,000 emails involved or 16 letters, all of the costs go up and down like a yo-yo. But on our companion webpage, Hull Estate Litigation, Hull Estate Mediation, we have a brochure on that page, and on that brochure we have set out the stages, and we've set out the costs that are estimated within those stages in a very, general way. So let's spend a few minutes now just talking about the stages and the costs that one could expect. So if we're going to have the guts to challenge a will, what are we looking at in costs, not just at the end of the day, but through stage one and so forth? And then we probably may not have time to go through all the stages and the amounts today with explanation, but let's start with stage one.
And stage one is the evidence gathering stage. And so what the ultimate goal on a will challenge, for instance, is to get to court to get an order giving directions. And what that order does is it organizes the litigation, it sets time frames for when things will happen during the course of the litigation, and who is responsible to do what. And I would say that part and parcel of that whole process is when you develop your case, to the extent that you can on a preliminary basis anyways.
Okay, so the client comes in and they're going to meet with you, and whatever hourly rates we're going to charge, it depends on where you're operating out of, but they're going to meet with you, so they're going to give you some explanation. That may take a couple hours. You might be at you might be at $1,000 pretty quickly. Then you're going to need to sign a retainer agreement, which will set out the contract in terms of the costs. And then this, as you say, this very preliminary stage, it's like a statement of claim or a writ being issued gets commenced. All right, so we've got that sort of very first step into the stage one. Let's explore that. Let's talk about the specifics on the costs that could be expected at our next podcast, and really walk through the practical implications of a lawsuit, and in the context of financial implications.
Great. Looking forward to that podcast.
Thanks very much.
Thank you.
You have been listening to Hull and Estate and Succession Planning by Ian Hall and Suzana Popovic-Montag. The podcast that you've been listening to has been provided as an information service. It is a summary of current issues in estate and estate planning. It is not legal advice, and you're reminded to always speak with a legal professional regarding your specific circumstance. To listen to other Hull and Hall podcasts or leave any questions or comments, please visit our website at hullestatemediation.com.